maybe we'll, in the interest of time, let's move on to our next speaker. Our next speaker is Dr. Sorry, what am I saying? I just read the D and said Dr. Judge David Orr. Judge David Orr started his legal career with Department of Justice in Newfoundland as a Crown attorney, and then entered private practice in 1981. While in practice, he chaired Legal Aid Appeal Board and the Criminal Law subsection of the CBA. He was a criminologist instructor at the Memorial University from 1981 to 2011, and bar admission courses instructor from 1995 to 2023. That's today, this current year. He was involved in design and implementation of mental health court and drug treatment court in St. John's, and has presided as the judge of the mental health court from 2005 to 2023. Again, that's current year. In the drug treatment court from 2018 to 2023. Yeah, so the floor is yours, Judge Orr. Take it.
Okay, well, thank you very much. I do have some slides I wanted to share, and let's see if I can get them. Oh, it's not them. Hang on. Let's see. There we go. All right, and should go. There we go. All right, so as was mentioned, what I was going to do is just briefly give an overview of what we're doing here in St. John's.
Hi, Judge Orr. We
yes.
can see your next present. Put it in the presentation mode, because I can see both of your next slide in this. If you put it in the presentation mode, then we'll only see one.
Oh, okay. Well, I have no idea how to do that.
Okay. All right. So at the bottom, you will see a presentation, a screen. If you click on that at the bottom of your PowerPoint slideshow.
Okay.
If you hover your mouse cursor on the thing, it will say something like a slideshow at the bottom, you know, where you have your, if
Okay.
not, it's okay. Try that, see if that works. If not, otherwise we can see your notes there, and but if not, that's okay too. Or click on the presentation, the big screen presentation kind of thing.
Oh, over here. That's the next slide.
No, nothing has changed. It's fine. Just continue. It's okay. In the interest of time.
Yeah. Sorry.
Yeah, let's just continue it. Yeah, that's no problem, Judge Orr. Thank you.
Okay. Anyway, in relation to that, have you seen that slide?
Oh yeah, we can see the slide. Yes.
Okay. The drug treatment court was started in 2018. It was designed as a collaborative project between the Provincial Court, the Newfoundland and Labrador Legal Aid Commission, the Department of Health, Community Services, and Public Prosecution Service of Canada. So it's a federally funded program. We already had two other therapeutic courts. We had the Mental Health Court, which we started in 2004, and the Family Violence Intervention Court started in 2009. They're all based on the same therapeutic model and therapeutic basis, and they all have somewhat similar procedures. There's a quote that I like in terms of the overall philosophy behind it, and this is from Richard Snyder's book, and he talks about therapeutic justice in terms of it focuses on the law's impact on emotional life and on psychological well-being. It views the law not as being neutral. The law and legal rulings have an impact on the accused, humanizing the law and concerning itself with the human, emotional, psychological side of the law and the legal process. So it's a different way of thinking about it. And what the idea is that the court is designed so that it's predicated on the relationship between the accused essentially and the judge and the treatment team. And it's a therapeutic and supportive relationship, which helps them to develop a strategy to meet the challenges that's brought the accused in conflict with the justice system. So it is a step out from the traditional adversarial approach, which I'm sure that everyone is familiar with. eligibility criteria for our court, it's an adult court, so you have to be 18 years or older. You have to have an addiction to drugs, either scheduled or not, but cocaine, methamphetamine, opiates, or prescription drugs. And there has to be a willingness to plead guilty and acknowledge responsibility. Now, not all therapeutic courts are set up with the guilty plea at the early part of the process. The mental health court doesn't do that, actually. The mental health court puts the guilty plea at a later stage. But the model that we're following is predicated on a guilty plea. Then the accused is on judicial interim release pending a resolution of the charges. The offenses that we're accepting have to be motivated by drug addiction, committed primarily to support drug addiction. They have to be nonviolent, and the accused has to have no recent significant history of violence. And you have to be within the jurisdiction of the St. John's Court. The reason for that is merely logistical, in the sense that you have to be able to attend court once a week. You have to go to the random urine screens, and of course, you have to meet with a therapist. Our therapy team is attached to the court, and we have a dedicated addictions counselor. Some charges that are not eligible, and these are the ones that are associated with violence, armed robbery, break and enter, personal injury, trafficking in drugs solely for profit, those involving youth or youth at risk, those involving drug-impaired driving, and related gang activity or organized crime. Now, as I'm sure everyone will recognize, that comes from the federal funding for the court, which it's predicated on. And so that's why the exclusions are there. That does have the effect of narrowing the net. What we have done when we're able to is sometimes you can deal with the facts of a particular incident where you can redefine the offense. So rather than break and enter, you can charge unlawfully in a dwelling or malicious damage or something to that effect. And that's what we're really trying to do, because we're trying to be as inclusive as possible. I think it's unfortunate that some offenses are excluded, because when you're using the therapeutic model, obviously any offender is going to benefit from the approach in most instances. And by having a hard exclusion for some specific offenses, I think it unnecessarily narrows the scope of what you could do. The fact that you're starting with a therapeutic process does not necessarily constrain the end result. But in any event, that's we have to respect the funding model that's there, and I guess we deal with it as it arises now. We do an eligibility assessment of the individuals that apply to the court, and we're attempting to identify high risk, high need individuals, and that's based on the R&R model in terms of risk, need, responsivity. And we're looking for current drug use. If you haven't been using for 6 months or so, or a year actually, then we're excluding the person, because obviously the offenses are not necessarily linked. With the criminal behavior, we also look for someone with a significant criminal history. And we have had situations where we do get some applicants that actually do not have sufficient need to warrant inclusion in the program, because it is designed for high risk, high need. In relation to the eligibility assessment, we're using an admission process which is a paper process. So the accused applies generally with the assistance of legal aid counsel or their own counsel. The Crown Attorney screens the offense for offense eligibility. The treatment team then assesses the person. We do a risk evaluation of suitability. They're using a couple of instruments to assess their suitability, the LSCMI and the DAST, and a couple of other instruments. that becomes important later on in the process because we're using the scores on that to measure the person's progress throughout the process. The assessment that we do have has evolved over time because we found that with the paper process, sometimes it's difficult for the Crown Attorney to make an assessment based solely on what appears within the four corners of the application. And so what we've done is we've elected in some instances the Crown Attorney may withhold their approval or rejection. And we move on to the risk assessment part of the process. And once that's completed, there's a team discussion in terms of whether or not the person could, in fact, qualify for the court. And what we're looking for is someone who's motivated to the program and also someone who we think we can work with and has the potential for success. So again, we're looking at trying to broaden our net in terms of accepting as many people as we can. The court process itself is similar to most therapeutic courts in the sense that you have an admission, a treatment, and a graduation process. With ours, it's a four-stage. And the first part of the orientation stabilization, that's when the person enters the court process. And we do have, from a procedural point of view, a 60-day period where the person can withdraw their guilty plea and go back to the regular court process. And by the same token, if it's apparent within the first 60-day period that the person is unable to meet the requirements of the court or just isn't succeeding, then of course we can send them back to the regular court process. During the orientation stabilization process, the person is trying to develop a treatment plan. And the treatment plan is then worked in through the case management treatment aspect of the second stage. And they follow the treatment plan with the goal to address the needs that they have. And thirdly, we move into the maintenance and aftercare, which to me is perhaps one of the most important or the most important part of the process. And that's where the person develops a go forward plan as to what they're going to do once they graduate from drug treatment court, to see if they've got some community supports. Have they got a relapse prevention strategy? Do they have family connections? Have they got proper housing? All of these things are with a go forward plan as to what they're going to do in the future. And the last part, of course, is the sentencing and graduation, which is the ultimate goal of the program. There's differences between the therapeutic courts, and I worked in all of them here, and I just thought I'd mention this. With the mental health court, the main difference is that more occurs outside of the courtroom in the sense that, more occurs outside of all the courtrooms, but in mental health court, the number of court appearances is less important because frequently, depending on the diagnosis and challenges the person has, court appearances are not necessarily of benefit to them and may actually impede their progress. So frequently you'll have persons who may appear only once or twice in the court. And the balance of the work is really done by the treatment team, who puts them in touch with the psychiatric help that they may need and other community supports. With family violence, the difference is chiefly, well, again, it's a therapeutic model, is there's a much larger role for the victims and families. Because it's predicated on the view that the person who's going through family violence is going to have an ongoing relationship with the others, usually. And there's often shared custody and or assets, and that, as a result, plays into that particular model. We use rewards and sanctions, as do all the drug treatment courts. And with respect to that, I would just note that with our sanctions, we use the traditional ones with additional court appearances, additional drug tests. We've also occasionally gone with written assignments. This is one that I find is useful in the sense that what it does is when the accused has had a problem with meeting a component of the program, if they then do a written assignment in terms of why they had that problem and discuss some strategies of how they can address it, it's a useful exercise in engaging the person in the process. The rewards, of course, are standard, and we're limited in what you can do. Coffee cards, grocery cards, week off court, things like that. Also, as they work through the process, court appearances become less frequent. And while looking at this from the outside, the rewards do seem sort of superficial, or in terms of being not that hugely significant. I just took a section out of a graduate statement on her graduation, and I think it shows her insight into her understanding of how the process was working. And I thought it was good, because what she said was earning rewards along the way felt like an accomplishment. When I earned the reward of coming to court less, I felt like I reached a major goal, and it gave me confidence. Well, as I said, from the outside, when you look at that, it doesn't seem like a huge kind of reward. When they're going through a lengthy process like our drug treatment court is, these acknowledgments along the way go a long way to the person marking their progress. And so it is a useful tool, and one that, I think is worthy of emphasis. This is just, I just included this as a reference point. This is what our treatment plans look like. And the advantage of the treatment plan is only this, and I know that everyone's familiar with this, but when you engage the person in the process, and they themselves are authors of the treatment plan or collaborators on the treatment plan, they're much more likely to be successful. Because when you've endorsed the process yourself and set your own goals, it makes it more attainable. And you'll see that it's quite a straightforward plan. You set out what the goals are, how you intend to reach the goals, how can drug treatment court help you attain those goals, and importantly, what are you going to know you've reached them? What's the outcome measure you're going to look at? So that's just an example of what we're using, and it's part of our it's part of our process, which we found to be helpful over the last number of years. We've developed one other aspect, and this is really coming from a court process point of view. We have what are known as continuation hearings, and this occurs when over time the applicant is not meeting the targets, and you reach a point where it looks like they're not succeeding. My concern was that as with most therapeutic courts, what we do is we have a meeting prior to court every week and discuss the progress of individuals and move on from there. And my concern was the process was becoming less transparent. And I thought it was important that the individual know these things and have a chance to properly address them in an open court setting, so everybody knows what decisions are being made and why. So what we do with our continuation periods is there's a written report made by the treatment team, and the accused is given an opportunity to respond to it. So this is an example of one. And what you can see from the continuation report is that the treatment team has identified what happened. In this case, the accused had a relapse and went back into drug use and actually committed an offense. And we discussed it with him, and initial thinking was that he might be discharged and sent back to the regular court process. However, on working with him and with the continuation report at the hearing, it was evident that he wanted to continue, that he was dedicated in terms of moving forward. And what we did is we came up with a response in terms of he returned to weekly appearances because he was on biweekly at that point, and his participation was going to be reviewed weekly. And that was the agreement that we made. I think that this is sort of helpful in the sense that when you have this kind of adjustment, it's more in keeping with the recommendations from Volume 3 of the Mass Casualty Report in Nova Scotia, in terms of the idea that therapy's got to be an ongoing process, and it doesn't make sense really if there's an opportunity to move forward that you abandon the effort at that stage. So this is one approach we've taken. Now, Naturally enough, not everyone's going to succeed at continuation level, but this is a process that we've added. Some of the issues and challenges that we have had with people that have been unsuccessful have been reoffending. Clearly, that's an issue. I have to admit that when we first started drug treatment in court, my initial approach was that if a person reoffended while under drug court undertaking, I didn't really see how they could continue. I've since softened on that issue. And in certain instances, if the offense that they have committed is one that was eligible for the court and can be included in their overall situation, then we've gone on to do that and included it, but it may result in the person being involved in the process for longer. Alcohol is a difficult issue. People tend to, on interview and being admitted, tend to underreport their alcohol use. And alcohol interferes with the other aspects of the programming. If it's an issue that becomes paramount in the sense that it's more significant than the drug use, we found that we haven't been able to work with a couple of applicants when that's been the issue. I don't know that what the appropriate response to that is, perhaps another therapeutic program, but it has been problematic with drug court. Mental health and concurrent disorders, what we've done in most instances with that, if the mental health challenge is more significant, we refer them on to the mental health court, and the mental health court has recently taken up some drug testing, so they are able to partner with us on that. We have had some successful transfers doing that. Just on that point, this is perhaps an obvious one, and one that I like in terms of, this is from Niles Olberg, who is the director of the Swedish Correctional Program. And they did a survey of all the persons in custody in Sweden. And one of the issues that they identified is that naturally enough, when you're involved in therapeutic courts, you tend to be sort of one-trick ponies in the sense that you tend to focus on your issue. But actually, when you're dealing with people in these situations, of course, individuals that have been involved in the justice system and have these kind of high risk, high needs have more than one problem. And it's the job of the therapeutic court to try and address as many of them as you can to come up with the appropriate treatment response. So that's just something you have to be aware of. We have our graduation requirements. We require a minimum of 9 months with abstinence from identified illicit drugs. No new charges under the criminal code or CDSA. I have to have compliance with drug court conditions and a demonstrated change in the need areas as updated in the risk and addictions assessments. So that's where the LSCMI comes back in. Well, I've just got a couple of slides there in relation to what a graduation looks like. And this particular individual came in and he was 21 months in our program. And you can see we used the LSCMI score. When he came in, he had a high score of 31, severe issues on the DAST. And at the assessment, he had work issues. He had little community support. He had limited family support. He had mostly negative peer. And the thing that he did have in his favor was he did have some housing and transportation. But he was certainly a high risk, high need individual. When you look at the graduation outcome, you can see by using the same LSCMI instrument, he reduced his needs to 16, putting him down to moderate. He had addressed issues and drug-related issues. He had peer interactions. He had family supports. And actually, he'd started his own business. I have to say that this gentleman was a real success story for us. And he suffered a traumatic injury through his work when he first started the program. And I really thought that when that occurred, that would prove to be too big an obstacle to overcome, but he did overcome it. And he said, and this again is from his graduation statement, he said that this shows the insight that he developed. He said that he didn't think that he'd be able to succeed. A lot of my breaches in the past were because of missing appointments. But I also like to have someone to run things by and dealt with people who didn't judge me, which was important for him and really is in keeping with our therapeutic model. So I think that he's a reason that the courts have succeeded, and I think that a lot of the work is due to our treatment team, or all the work is due to our treatment team and his own efforts. And uh, it's nice to have successes. Those are our numbers. I just did our numbers over the last 5 years. So we have had 90 applications. We've had 12 graduations, which is a huge achievement, I think. We have had 22 people that were unsuccessful at this stage, but I have to say that whenever someone undergoes the process and stays with the court for a number of months, irrespective of whether they ultimately succeed overall, they will have had an opportunity to address many of their issues, and you will see improvements overall in their overall lifestyle. So there is a benefit to the court process, irrespective of whether you ultimately reach the very high threshold that we improve for graduation. So those are just some of our raw data that we have for now. The other good news is that the funding has been secured for the next 5 years for the court, and we intend to expand to 3 more areas within the province over the next couple of years. So overall, it's a very positive experience that we've had. I like to thank you for inviting me to speak. I think I probably went through that fairly quickly, but I know that you've had a long day and you have lots of presenters. So,
In fact, Judge Orr, we let you go 10 minutes over the time because your presentation was so engaging that, yeah, I just could not say no to you, Judge. It's amazing. So what we'll do is this, the time is 3:10. Let's take a quick stretch break, come back. But Judge Orr, from the bottom of my heart, thank you. That was amazing presentation. Thank you. So let's take a quick 5-minute stretch break, come back at 3:15.